Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the managing partner of the Greater Toronto family law firm, Feldstein Family Law Group. Both myself and the entire firm practice exclusively in the area of family law, and we have offices in Markham, Vaughan, Mississauga, and Oakville to service you, and in the Zoom world, we can service the entire province. Today, we are joined by a very special guest, Mr. Jeff Hart, to discuss our topic of limited scope retainers. Jeff is an associate lawyer here at Feldstein Family Law Group. He was called to the bar in 2005 and has been exclusively practicing in the family law area since that time. He has experience with a plethora of family law issues, including custody and access, spousal and child support, division of family property, and child protection work. Jeff has appeared in the Ontario Court of Justice, the Superior Court of Justice, and the Divisional Court. Prior to joining the firm, Jeff practiced in the Halton and Peel regions, and when he is not practicing law, he enjoys, and I just learned this, reading, cooking, and spending time with his family. Jeff, thank you for joining us.
Pleasure to be here, Andrew. Thank you for having me.
And now that we know that you enjoy cooking, we'll have to have you bring some of your food to the office when times return to normal so you can feed everybody here.
Fair enough. Just let me know ahead of time about any allergies. I don't want to get sued.
Okay. Now, for all of the viewers out there, you can see the title of this show is Limited Scope Retainer. Do you want to explain what that means?
Sure. So, I'm not 100% aware if there's a technical definition of them, but we do them so often here. My thought on that is that's when a lawyer is hired to do a specific task or a specific series of tasks sort of grouped together, rather than the usual full-blown retainer where it's expected you take a case from the very beginning and run it right till the end. We would be asked to do specific things like write a letter or draft documents or attend a hearing. That's my idea of what a limited scope retainer is.
Well, I think it also would entail such things as coaching clients and helping them along the process. From my perspective, I've always looked at it almost like an a la carte service. When you hire us on a comprehensive retainer, that means we are your solicitors of record and we do everything. When it's a limited scope retainer, we include in our retainer agreement what we're doing, and you can hire us to do more or you can hire us to do less. And it's sort of like I said before, it's you go to a restaurant and instead of having the full course meal, you're saying, you know what, I'll just have a steak and you'll supply me with that steak. And I brought my own potato and I brought my own vegetables. Would you equate it to that?
I think that's a great analogy, actually. It's a smorgasbord. You take what you like, you leave what you don't.
And what would you say are the greatest advantages to the clients who opt for that process?
The first one that springs to mind is cost. So, if they want to provide a limited or a narrow scope retainer, I think in most cases it's far more affordable for the average client than the full, what I'll call the full freight retainer. So that's the biggest advantage that comes to mind. The second is that more control over the process by the client. Some clients do have a tendency to want to exert control, and of course on every retainer the client is in charge and we take instructions from the client, but some clients want to take that ability and run with it more than others do. So on a limited scope, it's win-win because the client pays less. The client, if he or she has a tendency to want to have more control, they have that control. And they know that ultimately how much we do and to the extent that we do it is up to them.
What would you say is the greatest disadvantage?
Lack of, if I were a doctor, I would say continuity of care. If you know what I'm saying, like to be parachuted in to do something and then to be pulled out to be extracted from the case, let's say, that's the biggest disadvantage to me, is because you're going to have a number of hands touching this file potentially if it's litigation. And so, like with everything, there's good, bad, and indifferent everywhere. So you may get, you may get quality work, you may not get quality work, but if it touches a number of hands, there's no continuity.
Well, I certainly think that's an excellent point. The other area that I say to clients is always challenging, and it's sort of along the lines of what you're saying, happens when they decide to draft some of their own material, whether it's letters or emails to the other side or actual court documents. And I say that because a lot of lay people, when they come in and they deal with family law, they have their own, I would call it, moral conviction that they believe is a truthful world. And then when we have a discussion that the family law world and their view of a just society are not the same thing. And that leads them to writing some really scathing letters or taking some really inappropriate positions. I always remember I once had a client come in who decided to do their own answer, and an answer is the response in a court document. And the answer was littered about their former spouses cheating, how they were useless, they never had a job in 20 years, and they were good for nothing. And it was littered throughout the court documents. And I see Jeff laughing because what that type of court document did is I had to immediately go into cleaning up a mess that was created, because a person may genuinely feel that way, and I'm not going to diminish their feelings and their emotions. But what is reality is that that type of approach won't work in a courtroom in front of a judge. And in fact, what that does is it really destroys your own case and is doing a favor to the other side, because then everything they're saying about you is going to be believed, because the court's going to look at you like you're a really bad person. So my first job, probably much like you would be doing, Jeff, would be amending that court document and wanting to clean up that client's litigation perspective as much as you can. And that same kind of viewpoint can come across in letters. So one of the things that I frequently say to clients, if they prefer a limited scope retainer, is you really have to be cognizant of what you're setting forth as positions, as offers, as in statements, and what you're saying, because you may do damage that I may not be able to fix. And I don't know if that's been your experience as well.
That has been, and you're absolutely right. I mean, a lot of clients, I would even say the majority of clients, see pleadings, see court pleadings, and even letters and correspondences to the other side as a sort of a palliative, like they get it off their chest. They have to get that, all of that stuff they've been holding inside off their chest, and they don't care who has to hear about it. And I mean, I understand that. I understand that, but at the same time, a lot of it is, as you say, at best irrelevant, and at worst, really so inflammatory that it detracts from the force of their arguments, because all the judge will see is how upset they are, and not how rational they can be, potentially.
And the point that I'm really getting at is I understand clients find lawyers' correspondence and emails to be expensive, and a lot of clients would probably prefer not to pay for it, and they probably prefer to draft it themselves. And when a client wants to do that, one of the things I suggest to them is I almost look at it like a launching pad. Perhaps I need to vet the first few that you write that have anything of substance other than saying what availability for a date is, and make sure that you're going along the right type of path, because it's so easy to go down the wrong path. And the other thing I've said to people frequently, when you have that email, and this really applies whether it's limited scope retainer or not, when you have that text or that email or that parenting app communication that just enrages you, or your ex did something to enrage you, go sit down at your computer, open your email account, and where it says to, leave it blank. Go write the email that makes you feel good. Don't ever send it anywhere. Delete it when you're done, and then write the one that you know is in your best interest. There's nothing wrong with getting it off your chest, but don't send it. Those are the emails that will come back to haunt you. You know, I think back to one client just on a check, when he would write his support check, he would put on the reline for the bloodsucker. You know, that, as funny as it is, it doesn't help your case. Or I had another guy. He was so angry with his ex-wife, and on a certain level it was funny, but not good for his case. He set up a website dedicated to his ex-wife, where when she would leave voicemail messages, he would play them with a monkey talking to just mock her. Now you can imagine that's not going to play well in court when she says, this is what he's doing for me. This is how disrespectful he was. My kids could have gone to this website. And those are the things I would say to somebody. If you want to do something where you're doing your own jokes for you and your friends because it makes you feel better and it's cathartic, do what you need. But make sure, if you're going to be, whether you're self-represented or limited scope retainer, you want to do that kind of joke, do it on your phone. Delete it when you're done. Make sure your kids will never see it. Your former spouse will never see it. And people can, and, if you want your brother to get a laugh, your sister to get a laugh, your new partner to get a laugh, great, all the power to you. Maybe it'll make you feel better and things will be better. But don't do it in a way that will be harmful to your kids and your case, and be cognizant of that. And it's the same idea when you're on a limited scope retainer. You really need to be careful with what you're putting in writing. And if in doubt, ask a lawyer. And one of the things I say to every client when they say to me, should I do a limited scope retainer? I give an answer. I equated one to steak and potatoes before. I'll equate this one to cars. If I ask everybody what kind of car they want to drive, everyone is probably going to say they'd love a Porsche, a Ferrari, a Lamborghini, a Mercedes, a BMW, or not even like a really nice car that knows how to drive. That's what most people would really want. Not everybody can afford it. So I say to most people, the comprehensive retainer is like going with a really good car. It's what's going to be the safest for you and it's going to be what's best for you, because if you drive that really fancy car, it's probably the best in an accident. But there's the practical reality that a lot of people can't afford that very fancy car. And if you can't afford it and you can afford something else, well, that something else may be better. It may be better to have a limited scope retainer. And I would equate it to driving a decent car that's safe, that can get you to point A to point B, because it may be better than doing it yourself, which would be like equating it to cars again, public transit, which I'm not knocking, but maybe a similar type of analogy. So comprehensive is going to be the best, and it's also going to be the most expensive. Limited scope is certainly better than being on your own, but mistakes can happen. Like you said, Jeff, too many hands can be touching it. Like I said, you can have mistakes in letters. So that's sort of part of the backdrop that I like to give to people about a limited scope retainer. And I'll give one example, and then I'm going to go to my next question. I once had a client, he did it in a really terrific way, how he used me for a limited scope retainer. His wife's lawyer brought a motion against him, and he was self-represented. Booked an appointment with me. We spent maybe 5-6 hours together where I drafted the responding affidavit for him. And I coached him of that 5-6 hours as well on how to argue the motion. And he went in and won, beat a very seasoned lawyer, because he knew what he was doing. His material was on point, and he was in a good place. That was really a good job of utilizing my services. Then fast forward a year later, he came back because he was in serious negotiations with the other lawyer of trying to resolve the case, and he needed my help to give him an opinion on where he should concede or where he should make compromises and where he shouldn't. And we made a counter offer, and I got on the phone with the other lawyer, and we settled that case. That gentleman, to me, was always a perfect example of how to use a lawyer in a limited scope retainer. But I have the caveat of he was smart enough not to send any really bad emails or court documents or communications that would make it difficult for us to resurrect him from. And I don't know if that's similar to your experience, Jeff.
It is. When you were talking about, that once that bad letter or that bad pleading or that bad message or whatever it is gets out there, it's impossible to, the horse got away, so there's no point in closing the barn door, and you can only really just try to, as you said, resurrect this person in the eyes of the court. And it's I lost a trial one time, frankly, because the client went and did this thing and put something out there on social media that she absolutely should never have done. And if she had asked me about it beforehand, I would have told her that's the absolute last thing you should do. And she didn't seem to think it was important enough even to raise with me. And then lo and behold, we're, 4 days into a trial, and I get this Facebook posting, as an exhibit. And basically at that point, the judge was basically like, yeah, I don't know what I'm supposed to do here. She basically admitted to doing all the things that she claimed in her material she hadn't done. So, it's it's a tricky one. I mean, if you've got a client that is what I'll call sophisticated enough to take your advice first of all, and to understand that saying there are some things that you cannot come back from, and if you say them or you write them, you're basically committing unforgivable sin in the eyes of a court, and it's much easier to prevent that, to have a prophylactic against that, than it is to fix it after it's been said.
And that's well put. And that's really the objective, is we're warning you when you do the limited scope retainer that we may not be able to protect you if we're not vetting every document before it goes out. And there is a problem in that if we are reviewing, there's certainly a cost for it. And once we review it, we may make sure that it's done our way, which may add some additional cost to it as well. So you have to be cognizant of it. And for some people, it works. And that leads me to the next question, Jeff. What makes a person less suitable for a limited scope retainer?
In general terms, it's part of who the person is and where their matter is when they come to you. I mean, my general preference is that if you're gonna come to me at the beginning, right? I mean, you don't want to be the second and third lawyer on a file. Generally, that's generally not good. If they've been through 3 lawyers, it might be because they won't listen to advice, which means why would they listen to you? But it's in general, it's that the more suitable would be the clients that are, they don't have to be high earners or have a very, a high level of education. That has nothing to do with it from my perspective. It's whether or not they take advice from their lawyer, and whether they ask the right questions, whether they speak to you before they do something, as opposed to speak to you afterwards and say, "Oh, was that wrong that I did that?" So the type of personality of the client, and it can be difficult to gauge that in even a 1-hour meeting. I mean, basically, it comes down to the lawyer having to ask a bunch of pointed questions about, hypotheticals, and if this were to happen, what would you say and what would you do? That's part of it, is the personality of the person. The other part of it is, where is the matter a litigation matter? If it is, where is it in the stream of litigation? I mean, are we right near the end here where I've got to, perhaps argue a trial on the strength of pleadings that I didn't prepare, or orders that have already been made that I had no hand in, and so I like to get the better ones are the ones at the beginning. That the ones that aren't in court yet, the ones that are at the very beginning of negotiations, those are the ones that I like to see, because like most lawyers, I'm a bit of a control freak. So I like to guide them before they go off the rails too far, or they've gone down the track too far to the point where there's no stopping the runaway train. Yeah, I froze there for a minute. I think we lost Andrew, guys. Let's give him a minute or so. He is a man who thinks before he speaks, but he usually doesn't take him this long. Okay, so in general, I mean, I look at it like, if I were to use a metaphor, I'd use the metaphor that I'm being parachuted in. I'm a paratrooper. I'm being parachuted in either, to secure a beachhead, in military terms, to secure something, or to protect something. So to ensure that something that is going well continues to go well, or to make sure that something that isn't going so well gets put back on the right track. I know I'm mixing my metaphors all over the place, but that's how I see my role in limited scope retainers, and the breadth or the depth or the narrowness of the particular retainer is completely up to the client, and what the client feels comfortable with, and what the client feels comfortable with handling him or herself, as opposed to handing off to me. Yeah. Okay. So as far as what the what would be the benefits to limited scope in terms of money? Yeah. Well, I mean, basically, to use Andrew's car analogy again. I mean, it'd be like renting a car as opposed to purchasing a car. I mean, possibly renting, possibly leasing as opposed to purchasing a car. Um, and if you're comfortable with the lawyer and the lawyer seems to know what the case is about and has the requisite skill and knowledge, then you only should really, in certain situations, you may not need a lawyer to do every little thing. Uh, you know, um, Read letters before they go out, written by the client. Perhaps talk to the client about potential responses to letters received from the other side. Assist them with the court procedure, because court procedure, especially now in the post-COVID or the pandemic era, is more complicated, and it changes all the time, and the rules are changing all the time, and to the extent where I hope I'm not alone in this, but I mean, we're constantly playing catch up and trying to figure out from one courthouse to another what procedure will work. And so to ask a layperson to do that on his or her own sometimes is a task that's just, it's too much for them. So I think that's where, especially where limited scope retainers can come in handy nowadays, is to assist with the procedural, always to assist with the procedural hurdles, but to deal with them on a more ad hoc basis, because they're changing all the time. And I think rather than have try to make it a one size fits all, cookie cutter experience, everybody's case is different. Everybody's case has different facts. Everybody's case has different legal issues. And so tailoring a lawyer's assistance to fit that, I think, just makes perfect sense. Yeah. Okay. So further to the point about COVID and how the world has changed. Yes. Well, I mean, from the very initial steps, I mean, where clients would normally come in for an initial consultation, they physically come into the office, and we would physically sit down across from each other, and I'd get out my pad of paper and my pen, and I would just have them tell me their story. Now it's a little bit better now. There are some people coming in, but for the longest time it was all Zoom. So because I mean we were under lockdown, so for the longest time you couldn't, and then the restrictions were eased a bit, but that it became people's comfort level, whether they wanted to be in a room with somebody else who they don't know or not. And most of them frankly chose not, which I always said to them, there's no wrong answer here. It's whatever you are comfortable with, because, I don't know your situation. You may have vulnerable people, elderly people, very young children, people with compromised immune systems at home. And I absolutely do not want to be, the cause of any more heartbreak than there already has been, across the world here. So yes, Zoom has been a very, perhaps the one silver lining with COVID is that there have been a ton of things gone virtual that I think would have taken years. And now they're a matter of course, because it was a necessity so that people could still function and the courts could still run, but without us having to be cheek by jowl in a courthouse or in a hallway. And along with that is the retainers have followed suit with that. So we can work out terms over Zoom. We can work out terms by phone. We can work out terms by email, none of which require in-person contact. So it looks like Andrew's back. Yeah.
Yeah, I'm not sure what happened. We're not supposed to drop because we have fiber, but this first time on a show I've dropped, and we got to watch Ask Jeff for a bit.
Yeah.
So I just, when I came on, I heard you talking about Zoom and the more efficiency of the court process, I assume.
Yeah, just how how limited scope retainers. I think at least for mine, most of them. I mean, the part of it that you won't escape with any retainer is assisting the client with court procedure, because that's why I believe, frankly, there can't be any clients that know it, and they've come to a lawyer for the very least to help them navigate the process procedure wise. And I was just explaining that the procedures are more complicated than they've ever been because they change all the time and they're very ad hoc depending on what the COVID situation is. And so I wouldn't even, if I were a client, I wouldn't even begin to be able to understand how to file things now, for example.
Well, it's fascinating you say that, because not only are the rules changing all the time, but there isn't one set of rules that apply across the province. They go from judicial district to judicial district, and then sometimes even based on courthouse to courthouse. So understanding the nuances of the rules and what proper services and how to file and the timing for that can be very challenging. But I will say this, if you are a client who is thinking of a limited scope retainer for a court appearance, the cost of the individual court appearance, in my mind, at least, has gone down significantly from Zoom. There's a few things that have made it far more efficient. I'll start with, if I have a motion scheduled in, I'll say, Toronto, I used to have to drive downtown and drive back from downtown. And in addition to that, I might wait 2 hours, 3 hours for my turn because there's a number of motions. Now, instead, I get a court date with a set time. I drive to my office. And when the court time starts, I log into Zoom. Maybe I'll wait 5 or 10 minutes, and then my hearing starts. So the amount of time that used to be wasted is significantly reduced. It's much more focused. You deal with the matter. In fact, I know one day I had I think an 11 o'clock court appearance in Toronto and a 2:30 appearance in Hamilton. And pre-Zoom, I would have been stressed beyond belief if I had to make those 2 appearances. Now I can. So I think that makes it better for a limited scope retainer. The only problem that you lose with that is, quite frequently, if I had that 10 o'clock motion in Toronto that I had to wait for 3 hours, I might have been able to negotiate a resolution of the matter while waiting. Now, instead, I'm not really going to be doing that time while waiting, negotiating. I'm probably going to be more likely to be arguing it. But if you're doing your job, you're hopefully trying to settle the motion before the day of the motion. And hopefully those issues can try and work themselves out. And when you get to the day of, you're arguing it. But there's no doubt in my mind, some of the costs, thanks to the Zoom world now, are far less expensive than it was before. And I think that's a wonderful thing for our clients, that they're not paying for us to sit around in court for hours upon hours to wait like they've historically done. I don't know if you'd agree with that viewpoint.
That's very true, very true. The court appearances now are like surgical strikes. We're in, we're out in the time allotted without a lot of fuss or muss or delay. And it generally is, I think, a positive for most clients. An hour court appearance is an hour, not perhaps 3 if you're waiting around or you're driving to or from.
Yeah. So from a client's perspective, I have no doubt that the Zoom world that we're in is far more cost effective for the clients. And I think that's a win for everybody. I'd much rather be effective and be billing for time where I'm doing work than all the time that gets stuck waiting around. I'd rather be moving on to another client. We're very busy. We don't have a problem with needing more work in that sense. So I'd rather be more efficient for the clients that I have and deliver a better result for them if possible. Jeff, I see we're just about out of time, even though I didn't make the whole show. It's the first time, and I don't know, first time it's ever happened. I don't know the total number of episodes, but it's the first time I've ever gotten logged out. But I'm sure you jumped in admirably to cover for me. So I wanted to thank you for being on the show, and thank you for taking care in my absence. The next Ask Andrew show is going to be on a date to be determined in December. We will send out our usual email blast, and we'll advise everyone of it. If you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.